Proclamation of 1938, now the Subordinate Courts Act of 1988. Resort is therefore had to civil procedure rules regulating the filing of affidavits in motion proceedings in order to fill the lacuna. These are currently the High Court Civil Litigation Rules of 2024 made under the High Court Act. The court stated in the Malawian case of Visikoti, Mwalimu and others versus the Republic that the law is well settled on the matter. Affidavit evidence in bail applications is treated in a similar manner to such affidavits in interlocutory applications within civil proceedings. Generally speaking, there are three sets of affidavits filed, namely, or in motion proceedings, namely, founding affidavit, which is the initial, answering affidavit, and a replying affidavit. A supplementary affidavit is used to provide additional information or to clarify points raised in the previous affidavits. Admissibility of a supplementary affidavit is a judicial discretion. Hence, a party seeking to file such must first seek the leave of court. The discretion must, of course, be exercised judicially. I'm fortified in this finding by the decision in former Lesotho Bank employees and another versus the liquidator Lesotho Bank and others, where the learned judge said that the court's decision should also be guided by considerations of fairness and whether the other party will be prejudiced by the filing of a further affidavit. Rule 68(1) provides that no further affidavits may be filed by any party without the permission of the court. The petitioner herein has not sought leave from this court to file a further affidavit. It will be highly prejudicial to the Crown if it is admitted when it has not had an opportunity to acquaint itself with it and react thereto. It is therefore expunged from the record of proceedings. On the application for bail pending appeal instead of ordinary bail, Advocate Fuma argued on this point that the petitioner has applied for bail pending appeal, but has failed to satisfy its requirements. It is his contention that such application for bail should have been moved before the same magistrate against whose decision the appeal has been lodged. Prospects of success must be demonstrated, and further that the provisions of the Subordinate Court Rules 1996. In motivating this point, he drew the court's attention to paragraph 3 of the petition, in which the petitioner averred that he desires to be released on bail pending his 2 appeals and or criminal trial in Criminal Trial 0615 of 2025. Reacting thereto, Advocate Putsani for the petitioner pointed out that this is a misdirection on the part of the Crown and insisted that the petitioner is applying for bail in the ordinary sense. As far as he is concerned, this was but semantics. In reply, Advocate Fuma underscored that this cannot be semantics nor an error, because the petitioner, even in his certificate of urgency, indicated that he was applying for bail pending appeal. Counsel referred the court to Advocate Sukonyala's certificate of urgency at para 2.6, that your petitioner stands, this is a quotation, your petitioner stands to be released on bail pending his 2 appeals filed in the High Court of Lesotho in Criminal Appeal number 0013 of 2025 and the other filed in the Court of Appeal of Lesotho in C of A Civil number 32 of 2025. The court wishes to point out that Advocate Putsani indicated at the outset that the petitioner is represented by 4 advocates, namely Advocate Lisinyeho, Sehapi, Sikwanyala, and himself. Hence, they keep interchanging. Advocate Putsani ultimately implored this court to consider substance over form. Bail pending appeal is a legal concept that presupposes that the accused has been convicted and sentenced. And as Advocate Fuma indicated, it has principles that must be met. As it is, the petitioner did not apply for ordinary bail for reasons best known to the petitioner's counsel. It was, however, brought to the court's attention that the accused has not yet been convicted. In conclusion, noting that the accused has not been convicted, the court condones the misconstruction by the petitioner of the concept of bail pending appeal in the interest of justice and considers the petition to be an application for ordinary bail. Following is the order. In the result, the court makes the following order. A. The supplementary affidavit is expunged from the record of proceedings. B. The matter is to proceed on the merits of the bail petition on Monday, 18th August 2025, unless the petitioner decides to amend the petition to include the new charge if he feels it will make a difference to his petition. And costs shall be costs in the cost. I think the judgment will be ready in the afternoon around 2:30.